Your Honor, for the record, Mark on behalf of the people.
Larry Brown on behalf of Mr. DeLucia.
Great. This is the date and time set for sentencing in this matter. Sir, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Brown about that?
Yes, I have.
Okay. Mr. Brown, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No.
Any challenges to the scoring? Do you have any victims that wish to address the court today?
No objections to the apologies.
Anything on behalf of the people for allocation?
Yes, sir. Thank you. 16, 12 theft, where the defendant says you can see it was adult record under items 6, 7, 8, 9, 10, 13, 14, 15, 16, 19, and 20. This defendant is a career thief whose record goes back all the way to 1995 present. Restitution in this case this time was $1,334. With this record in a guideline range of 36 months to 10 years, and the ongoing danger that this defendant presents to society, not just as the stores he steals from, but for the higher prices the community at large has to pay because of such activity. The recommendation has indicated simple probation. In this particular case, the opinion of the people is an insult to the court system and does not meet the 4 categories this court's report to look at with regards to sentencing. Thank you, Judge.
Thank you, Mr. Brown.
Thank you, Your Honor. Mr. DeLucia is 60 years old at this time. I did go over the PSI with him in detail that alcohol and substances like that are one of the biggest reasons that it just really affects him. He has mental health problems, which he is getting therapy for, and Hygira, I guess, it's an acronym for something. He attends AA regularly. He is on disability currently, but, and I understand the recommendation. I've never seen one like this, but I do think there could be a reason for that. Again, he is 60 years old. He has a horrible criminal record, which he does know. But he also has substance abuse problem, which he is trying to get help for. He wrote, the court should have a couple of support letters. One of those was his own statement, in which he readily admits that he is struggling, but he's been doing very well. But he has relapsed a couple of times, which I think we expect that, or the court generally expects that. But he has not picked up any new charges since he has been out on bond, except for the one in Wayne County or Washtenaw County, which is currently pending, I think largely based on this court's sentencing. So I think that because in Washtenaw, it is my understanding that he could be considered for sobriety court. Probation for 2 years, and I don't know what their sobriety court is like, but I would have to imagine that it is pretty similar to one up here and throughout the state. It is at least going to be a 2-year-long program. It's a very intensive program, and it has very severe sanctions. You can be sanctioned in the program. You can be violating probation. You can be resentenced on violation in addition to a maximum sentence of whatever the underlying charge is. So while probation is in one sense a privilege, it is also a very dedicated responsibility for anyone. And there is a lot at stake here. And he would be, one of the recommendations to be under tether as well. So he would be monitored. But this would potentially afford him the opportunity to get into a drug court rehabilitation program, which I don't believe he's ever done, and follow all of those rules and recommendations that he would need to do. But again, that is in another county. Depending on whatever this county does, obviously that is not going to be an option for him. So I would agree with the recommendation in this particular case. There's $1,300 and change to restitution to Walmart, which he fully understands that as well. And I know that the court has to do a balancing act here. And again, this is a rather unusual case. These are not really, this wasn't a violent offense. He does have a theft issue. And that is largely caused by his drinking. He has mental health issues. The alcohol just does something in his brain, which it does something to everybody's brain. But in this particular instance with him, along with his other issues, I think it just lowers his inhibitions so much that he doesn't think clearly, and he just has a tendency to steal. But I would not say that a probationary period, especially on tether and in a drug court program downstate on another charge where he will be monitored, is what we would call a get out of jail free card. It is a period of very strict supervision. It is something where he has an opportunity to learn and to do better. And it also has the added consequence that if he doesn't, he goes to one prison. So I would ask the court to take all of that into consideration in forming the sentence and do one that not only will benefit him, but will also benefit society in the long run. Thank you.
Thank you. Is there anything that you wanted to say today?
Yeah, I appreciate everything my attorney said, Mr. Brown said. I do accept responsibility for my actions. It's my own choices that brought me here today and nothing else. I don't blame the alcohol because it was my choice to drink the alcohol. I understand that my criminal record is not great, and I really don't have any right to ask for mercy from the court. I just ask that please follow the PSI recommendation and allow me to get some help and prove to the court that I can do better, because I know I will. I can't go on living like this. I've been living like this for almost 30 years. I worked very hard to get off parole after 20 years. Finally made it off parole in 2024. And I realized I caught a couple of the cases since then. But I've been working very hard to better myself. I go to AA regularly. As my attorney said, I had a couple of relapses, very brief, and I've caught myself very quickly and got back into treatment, which I go to Hagir regularly for substance abuse counseling and mental health therapy. And I also go to AA 3 to 4 times a week. I have a lot of support in AA, along with my family, a lot of really great family support. I just ask Your Honor to take that into consideration when sentencing me.
All right, thank you. Sir, I did read through the pre-sentence report. I'm familiar with all the information contained within that report. There's a lot of information about what happened in this particular case, what brings you before the court here today, along with your past history and your circumstances and so forth. And so I take all of that into consideration along with what you've had to say here, as well as the attorneys. Obviously, your record is something that stands out. I don't have many people in front of me who have a substantial of a record over as long a period of time as you have. And so that is certainly a consideration in the court's view. I think the circumstances of this crime, the fact that you do have another pending case involving a similar crime, and the fact that you weren't off parole for very long before you reoffended. When I look at the prospects of rehabilitation, those are things that stand out to me as well, in addition to, previous attempts at community sanctions. Based on the report, you've been on probation 7 prior times. And so all of those things together to me indicate that probation is not appropriate in this case. If it hasn't worked 7 times, if parole didn't work, if you reoffended almost right away after being released from parole, I don't see the point in continuing another term of probation. So the court finds that a Department of Corrections sanction is appropriate given your actions in this case. I don't know what's going on in the Washtenaw County case. I have no idea, other than what's been said here in court today, what the prospects of some type of treatment court would be there. So I can't really rely on any of that without more information or some kind of documentation of that. And frankly, even that might not be enough from my standpoint, given what's happened here and given your prior history. This is a nonviolent offense, so I don't think a sentence at the absolute top of the guidelines is warranted. However, again, I do think a Department of Corrections sanction is called for. The court is going to sentence you to, guidelines are 12 to 36. The court's going to sentence you to 24 months to 10 years in the Department of Corrections. You have credit for 2 days served. The court is going to order restitution in the amount of $1,334. That's payable to the Otsego County Clerk, be dispersed to Walmart. The crime victim's assessment of $130, court costs of $325, attorney fees $350, $68 state costs. So you do have the ability to seek an appeal of this sentence. Those papers are going to explain to you how to request an appeal, as well as how to request a court-appointed attorney to help you with any appeal.
Your Honor, Mr. DeLucia has acknowledged receipt of his appellate rights. I'm tendering that to the court.
Thank you. Mr. DeLucia, you are permitted to cut the state of this. Are we bringing Mr. House up? Is that next?
Yes, sir.
No. We're going to take a short recess until we have Mr. House. We're on the record in People versus House. This is file number 226424 and 266996. The record should reflect Mr. House is present here in the courtroom today. If I could have counsel put your appearances on.
Larry Brown, on behalf of Mr. House.
Thank you. This is the date and time set for sentencing on both the probation violation and the new charge. Mr. House, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Brown about that?
I did.
And Mr. Brown, I received a number of character letters on behalf of Mr. House. So Mr. House, I received all those letters. I had a chance to review those prior to the hearing today. Mr. Brown, are there any other additions, deletions, or corrections to either of the reports?
No, Your Honor, and we'll challenge this.
Thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
No, you're right. Thank you.
Any challenges to the scoring?
No, Judge.
Anything on behalf of the people for allocution today?
Yes, Judge. And I also had an opportunity to review the reference character letters that we got. So I wanted to look at that. And by looking at that, it appears that there are unfortunately two Mr. Houses. One of which, a gentleman, when he was not consuming intoxicants. The other gentleman, when he is consuming intoxicants, decides to get behind the wheel of the vehicle. It's a circumstance where, as the court's aware, the defendant has, this would be his 7th and 8th felonies. The situation, or 7th felony. It's a situation where the defendant, in this particular case, has a number of prior drinking and drivings. I would note that apparently that, as indicated under 913, he was given 3 years probation with 30 days up in jail. That's number 913 on September 18, 2020, and then under number 11 of 13 on his 4th and driving August 9th, 2020. He also got a probationary time period with a limited amount of jail. There's a recommendation in this particular case of, and I understand, and I guess I should preface this, is that it is my understanding that that recommendation isn't really coming from our local probation and parole department. It's my understanding that that's coming from Lansing, effectively. Bluntly. I understand that they can take that position, but I also understand as the court, I know does, that the court has a number of factors you have to look at, and concerns you have to specifically look at as recognized by case law. One of those is, of course, punishment. One of those is rehabilitation. One of those is safety of the community. For reasons which I don't know, Mr. House chooses not to consider safety of the community when he chooses to get behind the wheel and still drive the vehicle, placing himself and others in danger. And I think the court should be taking that into consideration, and we should not be looking at a probation sentence as well. Thank you.
Thank you, Mr. Brown. Thank you, Your Honor. Mr. House is 38 years old. My entire docket today in front of this court consists of offenses related to alcohol and drugs. It is a very common issue. In speaking with Mr. House, he does realize that he has an alcohol problem, but he does have a lot of good qualities. So I would agree with Mr. Rolla, as well as those support letters that came to my office and I forwarded, that he has a lot of good qualities, and alcohol just does something to him. Everybody has a different reason for doing it. I don't think he does it to get high. I don't think he does it for those reasons. He essentially has long periods of sobriety, or can have long periods of sobriety. If things go wrong in his life, maybe he has some kind of underlying trauma. I'm not sure what that would be, but this is how he medicates himself. It is a short-term fix, and it is not a good fix. I think he realizes that. He just has a disease here that's very difficult to get over. To his credit, He does have full custody of his daughter. And there's a lot of good things that can be said about it. It was something that he kind of grew up with a little bit. It was in the home periodically. And that is just kind of how he learned to deal with tough situations. There's a lot of other things out there, therapy, many things that you can get into. But when you're in a certain state, you don't necessarily think about those things. It's very easy to just run bottom. So I would ask the court to take all of those things into consideration. I know that court, as does he, the court has to do a balancing act. There's got to be a degree of punishment. There's got to be a degree of deterrence. But there also has to be a degree of rehabilitation so that this isn't a continuing issue within the community. So I would ask the board to fashion a sentence around some degree of punishment, but also to really concentrate, especially given his age, he's young enough to still be rehabilitated if he gets into some proper services and therapy. Excuse me, to concentrate on that as well.
Thank you. Mr. House, anything you wanted to say today?
Yeah, I just want to add that it's substance is destroying the blood. I've done almost a quarter of my life in trouble. Definitely. I just need help.
Well, Mr. House, like I said, I read through all the character letters that were submitted on your behalf. I certainly take those things into consideration. I agree with the lawyers that those letters paint a different picture or a separate picture of you than the information contained within the pre-sentence report. And that's fine. Nobody's all one thing. Everybody has different qualities, and people can be really good in some ways and not good in others. Unfortunately, for all the good qualities you have, your shortcomings are the type that have put yourself and other people in danger continuously. And a lot of the things that your attorney talked about, which are all good points, but they're all points that we talked about at your last sentencing. And you had an opportunity through the probation. I held your jail time and a lot of it in abeyance. We put you on probation. You had a full and fair opportunity at that time to avoid more serious consequences. And when this case came up, honestly, it frightened me a little bit because I'm the one that gave you that chance. And if you would have hurt or killed somebody this time, you're gonna be like, what's wrong with that judge for letting this guy out with his history of drinking and driving? And I think, all the people that support you might be looking at this differently if you hurt or killed somebody, because you're out there driving around at 6 o'clock in the morning at almost twice the legal limit when you're already on probation for the same thing. And I think it's really lucky that you didn't hurt or kill somebody that morning, including yourself, because from what I read in the report, you went in the front end of treetops and came out the Marquardt side, and there's some pretty steep hills and pretty sharp turns going through there. So I think this could have resulted in a much worse situation than it did. But in terms of another chance, in terms of leniency, you've had that opportunity. I gave you that chance already, and that didn't work out. And I'm not willing to continue to give you the same chance over and over again and risk the same results. I have a responsibility to look out for the safety of our community. And I think at this point, you've shown that when it comes to alcohol, it's not safe to have you out there. And so for those reasons, on the new case, the court is going to sentence you to the Department of Corrections court is going to sentence you to 24 months to 5 years in the Department of Corrections. You have credit for 2 days served. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $68 state cost, and fine of $500. With regard to the probation violation, court is going to sentence you to 12 months in the Otsego County Jail. You have credit for 198 days served. That sentence to be served concurrent to the sentence in the new file. In that case, the court will preserve any outstanding fines and costs. You do have the ability to seek an appeal of both of these sentences. Mr. Brown, if you can let me know once Mr. House has acknowledged the appellate rates.
Your Honor, he has signed that acknowledgement of both of these files, and I'm tendering those to the court.
Mr. House, you are remanded to the custody of the state at this time.
All right.
Mr. Miller present.
Your Honor, that one was adjourned
What was?
by stipulation.
Oh. Yeah, Mr. Hebert present. Sir, if you can come up to the podium, please. Record should reflect Mr. Hebert's present in court today. We're on the record in file number 266983. Like you had counsel for your appearance.
Terry Brown, on behalf of Mr. Hebert.
Thank you. Okay, Mr. Brown, how did we want to proceed on this file today?
Your Honor, this was adjourned from the last hearing due to Mr. Hebert having some questions and some issues and things we need to go over a little more. There has been an offer made in the matter that if you please count 1 and 2 with a $200 reimbursement at or before sentencing, then the enhancements would be dismissed, and I believe that is the way it needs to.
All right, I was looking for the information, so I'm sorry. Can you state that again?
Oh, I'm sorry. Plea to counts 1 and 2 for dismissal of the enhancements.
Okay, thank you, Mr.
That's
Rowe.
correct, Judge. With the $200 reimbursement fee at or before sentencing.
Mr. Hebert, am I pronouncing your name correctly?
You are, sir.
Did you have a chance to discuss this plea agreement with Mr. Brown?
I did on Monday.
Do you need any more time to do that before we proceed?
No, sir.
Is that how you wanted to go forward today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Hebert, are you currently on any kind of probation or parole? And you understand that by pleading guilty to count 1, which is operating while intoxicated, as a third offense, that the maximum possible penalty you can face would be up to 5 years and or a $5,000 fine. And that by pleading guilty to count 2, which is operating a motor vehicle without security, that's a misdemeanor that carries with it a maximum penalty of up to 1 year and or a $500 fine.
Yes.
With all of those maximum possible penalties in mind, what is your plea to each of those charges today?
Yeah.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
I do.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, which means you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand?
Okay.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today? Is it your own free choice to enter this?
Yes.
Are you pleading guilty to these charges because you are actually guilty?
I'm guilty.
Right. This happened around February 23rd of 2026. Is that the correct date?
That's correct. Yeah.
And on that date, had you consumed alcohol?
Yeah, it was a suicide attempt.
Okay. How much alcohol did you consume?
A little over a pint, probably.
And after you consumed that, did you operate a motor vehicle on I-75 here in Otsego County?
I did.
And when you were operating that vehicle, had you consumed enough alcohol that you were intoxicated?
Yes.
Did you have any blood or breath tests to determine the level of alcohol in your system?
I don't remember what it was, but I know I took the test.
Judge, I believe the parties would stipulate the blood test results were 0.266.
Okay. In any case, Mr. Hebert, do you have any question that you're over the legal limit of 0.08?
There's no question.
Okay. And had you previously been convicted of operating while impaired in 2025 in Alger County?
Yeah, I was on my way to rehab and I was having restless, I was coming off of opiates. Oh, no, sorry. Yeah, I got convicted then too.
Okay, and also in 2010 in Chippewa County?
That's correct.
And then back to this incident, at the time that you were operating that vehicle, did you have insurance on that vehicle as required by law?
No, I did not have insurance on my car.
All right, Mr. Rollard, the people satisfied with the factual basis?
Just court takes judicial, this was on public.
I think we did get testimony, it was on I-75.
Oh, very good. Thank you, Judge.
Mr. Brown?
There it should.
Counselor, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
By the people, thank you. By the best.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Yes. Thank you. Mr. Hebert, the court finds that your plea is knowing, voluntary, is accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to each. We'll set this matter for a sentencing date. You'll be notified of the date and time of that hearing. You're going to meet with Mr. Brunikel briefly here after court to set up the time for a pre-sentence investigation. Once that report is prepared, you'll have a chance to go through that with your attorney. Do you have any questions? Thank you. That's all for today. All right, sir, can you tell me your name at the Presque Isle Jail, please? I think you guys, you're either muted on your end or the microphone isn't on.
Is it good now?
Yes, yep, can you tell me your name?
Matthew James Bohr.
Okay, Mr. Bohr. We have you set for hearing at 2:30. So your attorney isn't here yet, but I'll recall your case at 2:30. I don't know if they'll have you just stay right there, but I can leave you connected and, but I'm gonna mute you until we're ready for your case, okay?
Thank you.
Mr. Brown, are you ready on Ms. Ferguson's case?
I am, Your Honor.
Ms. Ferguson, you can come up to the podium, please. We'll go on the record in People versus Leah Ferguson, file number 26-6988. The record should reflect that Ms. Ferguson is present here in the courtroom today. This is the date and time set for a sentencing hearing. Ms. Ferguson, did you have an adequate opportunity to go through the report and talk to Mr. Brown about that?
I did, sir.
Mr. Brown, are there any additions, deletions, or corrections?
No, Your Honor, and no challenges to the story.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections, or challenges as well.
Anything on behalf of the people for allocution today?
Judge, it's actually in that case, second felony situation is prior to both substances. So, 16, guidelines for this lower because it's 17 months up to 10 years. If the worst situation, actually 10 months, we could change that. However, under the circumstances, instead of being two, she's a recognition is.
Thank you. Mr. Brown.
Thank you, Your Honor. Ms. Ferguson is 38 years old and she stands before the court today. I'm sure the court has gone through, as it generally does, very carefully with PSI. She has been homeless since about 2013 after she got a divorce. Her husband got custody of that child. She had a relatively very traumatic upbringing where she was sexually abused. And ever since that time, she just uses substances or has used substances to kind of cope with life. She has tried to take her life in the past. She got mixed up with the wrong crowd, which is never good. Birds of a feather, I guess they say that, you know, you can find some solace in people that are dealing with similar issues. Unfortunately, those people also that you hang around with deal with those issues in the same way. And that is kind of what she got caught up with. She has made very good time and valuable time while she has been incarcerated. She goes to every service they have in the jail. She goes to AA. She said she does have a sponsor. She goes to the church group that comes in. There's just a lot going on, and she's really trying to overcome it. She actually said she wants to be a recovery coach, which, I mean, it's a laudable goal, and I think there's nobody better to do that than somebody who has suffered through something like this and then finally been able to overcome it, somebody that can relate. She did kind of intimate to me that when she was in Wexford County Jail, she was cellmates with a 60-year-old lady, a 60-year-old woman who was in there for the same thing, drugs. And I believe that had somewhat of a profound effect on her. Looking at her at 38, looking at this woman next to her at 60, still doing the same thing. But she does not want to turn out that way, does not want to be there. She has got a lot of mental health issues again that she really needs to deal with. The work with, I mean, the facts in this case are she was basically sleeping in the waiting room to feel MH. And the officer came and talked to her, and she gave him, I mean, she wasn't trying to hide it. She's just really searching for something to be able to cope with all of the experience she's had, and more than likely are going to continue to have, because that's just life, with some of the mechanism other than drugs. So I would ask the court to fashion a sentence and take all of that into consideration. When I speak with her, she's very polite, she's very nice. She's not using, I'm sure she's just one of the first to be around. So hopefully she can get the help she needs. Thank you, Judge.
Ms. Ferguson, anything you wanted to say?
Your Honor, first want to apologize for my actions. I chose to knowingly relapse when I took the advisor choices. The time I have sat in jail has really opened my eyes and has been used wisely. I attend most every church service. I do attend every AA meeting, and I've also got a sponsor who helps me understand things that I couldn't without her outpouring compassion, love, and support for helping me. Please find it in your heart to allow me to get into rehab or sober living. I feel either or would not only help me stay sober, but to also further my education and knowledge of addicts. Because my dream career is to be a juvenile your recovery coach. Thank you for taking the time out of your busy day to listen to what I have to say. Again, I am trying to improve myself for the better.
All right, thank you. Ms. Ferguson, I did read through the pre-sentence report, so I'm familiar with what the information in the report and how you come before the court here today. And I did read what Mr. Brown indicated. You're at the hospital, didn't have anywhere to go. They were allowing you to kind of stay in the waiting room there overnight.
I was trying to get down to Pine Rest, actually.
Okay. And then the police came and they actually took you to treatment, right? And then, but you elected not to stay for whatever reason. And then that's, I just want to make sure I understand what happened here. And so number one, I think it started off as a really positive interaction. You're somebody there, the police actually took you to treatment instead of arresting you right then and there. I think that's a positive thing. I'm glad to see that. I hope that happens more. And I know that the local police do work with organizations like Families Against Narcotics, where they try to offer that as a first solution to somebody who's just using and isn't otherwise causing problems. And so I recognize this wasn't any type of assaultive offense. It's really just a use offense. And so I don't think that any additional jail time is warranted. You served 93 days. Guidelines are 0 to 17. I don't see any aggravating factors here or really anything to be gained by keeping you in jail for longer than you've been. I think to the extent a penalty was necessary, I think 93 days is sufficient. I just would say, from what I read in this report, I wish you would have stayed at treatment that night. Number one, because you wouldn't be here today, probably, because I don't think they were going to charge you at that point. But number two, because I think you need that, and you can get yourself there. We're going to be releasing you from jail. I'm not putting you on probation or anything. It's just going to be a fines and costs sentence. So you're going to be kind of on your own. You've been on probation 6 prior times, so I don't see a benefit to doing that again here. But that doesn't mean that you can't seek out the help on your own, that you can't go to treatment on your own. You don't have to have the court order it. You don't have to wait for a probation officer to force you to do it. You can leave here and go right there today if you can find a way to get there. So, and I hope that's what you do, because you're right, you're almost 40 years old. So now's the time to get some help. It's not something you can do on your own.
Right.
And I think if you could work on that and become a peer recovery coach, you're the type of person who could be really good, because you've lived it, you've been through it.
Yeah.
But you got to help yourself first before you can help others. Yeah. So the court is going to sentence you to 93 days in the Otsego County Jail with credit for 93 days served. The court is going to order a crime victim's assessment of $130. Court costs of $325, attorney fees of $350, and $68 state costs. You have the ability to seek an appeal of the sentence. The paperwork that you just received will explain to you your fellow rights, as well as how to request a lawyer to help you with any appeal. That's all for today. Good luck to you going forward. All right, we're going to take a brief recess. Mr. Boer's attorney is not here yet. We've still got about 5 minutes before the hearing time, so we'll take Okay, Mr. Bohr, if you can unmute yourself. And Mr. Perney, are you able to hear me okay?
Yes, Judge. Hi, good afternoon.
All right, good afternoon. We'll go on the record in People versus Matthew Bohr. This is file number 267005 and 7006. The record should reflect that Mr. Bohr is present today by Zoom video. We have Mr. Perney by Zoom on his behalf. Mr. Rolla is present here in the courtroom today. Mr. Perney, can you tell me the status of these two files here today?
Yes, Your Honor. Thank you. I've been in contact with obviously my client. He still has a violation of probation in Presque County, which is where he's being held. They're kind of at standstill in the Presque County Jail, or that jurisdiction rather, seeing what we're going to do here. My client was interested in your local treatment court. I did have the prosecutor's office forwarded me the application, which I hand delivered to my client. He completed it and submitted it to Mr. Luke Hamlin. He's been in contact with Mr. Hamlin about 3 times. I've been in contact with Mr. Hamlin, and he indicated to me that Mr. Bohr is a good candidate, that there is a process, and that if he were to be able to be released from custody, which is a requirement, that he could finish the intake and the procedure, or the process rather, and he could have the report to you, Judge, by the 27th of July. So if the prosecutor doesn't have an objection to move forward with that, I'd ask the court to consider that. He said to hold off on any plea, he being Mr. Hamlin, any plea with you, Judge, until he is fully screened with Mr. Hamlin, and then we could come back around the 27th of July, or a date that works with the court, so long as the people have no objection.
Mr. Rolla.
Judge, under the guidelines of the sobriety court, the defendant's got 2 charges of delivery of meth. He wouldn't qualify for this.
All right.
So I'm not sure where that's coming from.
Is that based on our policy or based on the statute?
A little of both, actually. Because it's a delivery charge. There's an offer in this case of counts 1 in each of the 2 files and dismissing the others. And in this circumstance, it would, I mean, I'll be happy to look at whatever paperwork you file. I'm sure Mr. Fournier, APA Fournier in our office, because he's our representative on the drug court, will look at it, and the panel will look at it. But again, I don't want to burst anybody's bubble, but I think the likelihood of Mr. Bohr qualifying for drug court, I would not be inclined to believe his odds are very good. So I don't know where that's coming from.
All right. Well, do you have an objection to the adjournment?
I don't have any objection to the adjournment, Judge, but at this point in time, unless I see something I'm unaware of, it's my understanding our office would probably be objecting to that in any case.
All right. Well, Mr. Perney, I guess what I would do then is just set this out for another status conference or plea hearing at the court's next available date, which would be, I believe, August 5th.
Okay.
And you know, if he qualifies and he can get in, then we can go forward at that point. If not, then we can talk about other options.
Well, Judge, the caveat, like I said earlier, I did say a lot on the record, is that he can't complete the process while he's in jail, regardless if he's in Otsego County Jail or in Presque or Alpena, doesn't matter where. They have a new process, Mr. Hamlin said, where he has to be out of jail to complete it. And so I don't know what his bond is currently with you, Judge, but if he's out on tether or to some nature like that, so he can be released to complete the process. Otherwise, this conversation's moot.
Well, it looks like his bond here was canceled by prior counsel in both files at the district court level.
And Judge, I think that was done because he was sitting in Presque County Jail and didn't want to have.
So I don't know, Mr. Rolla, what's your position on the bond then?
I mean, sitting out of PV right now.
Your Honor, we have court next Monday with Judge Gothier in the other jurisdiction, in 53rd. And we can, he can do whatever he wants, obviously, but he kind of wanted to see where we stand on this here because he doesn't have a bond over there. So if I can get some order or something from you with a, reasonable bond. So obviously I'm mentioning tether and stuff, but I don't think he's going to flee anywhere, Judge. But to make both the people and you feel comfortable, have him released on tether. And then I can present that to Judge Gothier, and then I can have him meet with Mr. Hamlin. So there's a lot of moving parts here, but I'm advocating for my client the best I can, Judge.
Sure, absolutely. Understood.
In regards to concern about fleeing, I'm not as confident as defense counsel is, because as a habitual court, your guidelines in this particular case are 72 to 180 up to 40 years is a half third, and 72 to 240 up to life on a half third. So I mean, this is a prison sentence situation.
Yeah, understood. I guess, Mr. Kearney, what I'd like to do, unless either of you would object, is to, I'd like to have some communication with Mr. Hamlin.
Okay.
Because, and that may be a new policy that he's got. It's not something that I'm aware of. I've never had that brought up before, that somebody who was lodged even here at Otsego, that they couldn't go forward with the treatment court program because they were currently lodged. But that may be a change. So I just want to talk to Mr. Hamlin to see what we could arrange. But I don't want to set a bond today without having that communication.
What's as soon as we could come back, Judge? Do you think Monday, do you have a court docket Monday with the state?
No, but I have your motion on the record. And so I can either grant or deny that by written order. And if I grant the request for bond, then I'll just simply issue a pretrial release order with bond amount.
Okay. I mean,
I don't
Judge,
have any hearing date. I wouldn't have any hearing. I'm in trial next week. I would not have hearing dates available here in Otsego County until August 5th would be the next date. So,
okay. All right.
but I mean, if you're asking for an answer here now on the record, I'm not going to grant that request. But if I have communication with Mr. Hamlin and
Perfect.
be able to confirm with him, because I don't have an objection to your client even at least being screened for the possibility of treatment court.
Yeah, I think that would be, I mean, he needs it, Judge, and this is something that his family wants, he wants. I mean, could we come back? I mean, the oral, obviously, motions put on the record. He wants to get this moving as fast as possible because he's been there so long. Is the earliest you can do in August, Judge, or can we come back in a few weeks?
Yeah, that's my next possible date would be August 5th.
Okay. All right. That's what we'll have to do, Judge.
I have a 3-county circuit, so
Yeah,
I'm in
I get it. I get it.
different places at different times.
I understand.
Okay.
Thank you, Your Honor.
All right. So at the very least, we'll be back for a status conference plea hearing at that August date, and then whether or not the court's going to take under advisement whether or not to grant a bond for purposes of applying to sobriety court here, and then of course I don't have any control over what Judge Gothier does.
Sure.
There. Okay.
Sure. And I'll be in further conversations with Mr. Rolla.
Thank you. Anything further, Mr. Kearney, on this file today?
No, thank you for hearing everything.
Mr. Rolla?
Nothing further. Thank you.
Okay, thank you. You're free to disconnect, and Mr. Bohr, I'm going to go ahead and disconnect from your side as well.
Thank you.
Okay. Mr. Dick, were you ready with Mr. Haskell's case?
Yes, sir.
Okay. You and Mr. Haskell can come up to the podium, please. We'll go on the record in People versus Hassel. This is file number 267010. The record should reflect Mr. Hassel's present here in the courtroom today. And the AG is signing in here. So it's just All right, counsel, can you unmute and place your appearance on the record, please?
I apologize. Good afternoon, Assistant Attorney General Carissa Williams on behalf of the people.
All right, thank you. We're on the record in People versus Hassel. Mr. Dick, can you tell me what the status of this file is here today?
Yes, Your Honor. This is the first hearing in the circuit court since the preliminary examination. The Attorney General's office, Ms. Williams, and the other Attorney General handling this matter, or sorry, Assistant Attorney General handling this matter, and I have been communicating. Today, we are requesting a 90-day adjournment to allow Mr. Hassel to establish a payment history to be able to take part in a plea offer that we made.
All right, Ms. Williams, were you able to hear that?
Yes, Your Honor. In reviewing my colleague's notes, Ms. Messer may be the attorney that I think has been on this case the most. She's the assigned attorney for the county. I would have no objection to that. It does look like there was a payment made last month. So we would just look forward to him keeping that up and establishing payment history over the next 90 days.
Okay, Mr. Hassel, have you had a chance to talk about this with Mr. Dick?
Yes.
And do you have any objection to that?
No, Your Honor.
All right, so that's how we'll proceed. The court will set this for another status conference in 90 days. So Mr. Hassel, it's just important that you stay in touch with your attorney between now and then. Mr. Dick, is there anything further for today's hearing?
No, Your Honor, thank you very much.
Ms. Williams, anything else that we need to address today from your side?
I just need to verify that the court will send the next court date.
We will send the next court date, and the court will allow your office upon request to appear by Zoom.
Okay. Thank you, Your Honor.
Okay. All right. Thank you, Mr. Hassel. That's all for today. Mr. Dick, your next case is Mr. Schneider. I know that you've not had a chance to review the PSI because it's lodged at Department of Corrections.
Yes.
So once they're signed in, I'll give you an opportunity if you want to go ahead and get signed in to Zoom so that when they're signed in, do that right away and then proceed. All right, Mr. Schneider, are you able to hear me okay?
Yes, I can, Your Honor.
All right, so we do have a hearing scheduled for sentencing in your case. But your attorney's indicated that he has not been able to go through the PSI pre-sentence report with you yet. So I'm going to place you into a breakout room with him so that you can have a private conversation before we go forward with your hearing. So I'm going to go ahead and do that right now.
Okay, thank you.
Okay, we're back on the record now in People versus Schneider. Mr. Schneider, did you have an adequate opportunity to speak with Mr. Dick about the PSI?
Yes, Your Honor.
All right, and Mr. Dick, I know we've got some challenges to the scoring, but before we get to that, are there any additions, deletions, or corrections?
Your Honor, the one correction I would like the court to perhaps entertain was the status at the time of offense.
Okay,
So the PSI that was submitted in this matter was a PSI update. The original PSI from very recent matter was the status reflected. Aside from that, Your Honor.
can you say that last part again? I didn't hear what you said.
I'm sorry, I said aside from that, Your Honor.
No, before that, about what needs to be changed.
So CFG 101, I guess it would a correction slash a challenge, I guess. Just the status at time of probation on page 1 of the PSI update.
Okay,
It does say that he was on probation at the time of the offense. However, the original PSI that this is reflective of put status at the time of the offense.
okay, so he was not on probation at the time?
So I said that would also likely be a challenge, so I didn't want to confuse the court. My apologies. I guess under the circumstances, that should probably just be best left as a challenge
I don't know what you mean by challenge.
to the guidelines, or the fact that he may not technically have been on probation at that time.
Which guideline are you challenging with that?
Yes, that would be the relationship to the criminal justice system.
Right, that's not one that you previously challenged, so now
No,
you're
Your Honor.
challenging an additional. Okay,
Yes.
Judge, in that regard, under page 1 of the evaluation plan, 1, 2, 3, 4, 3 paragraph, it shows that the defendant was on probation on the state of California. And it's from the robbery offense from 2005 interstate pickup. So yeah, he may not have been on probation here, but that doesn't mean he wasn't on probation.
all right, Mr. Dick.
Your Honor, I guess as far as that goes, the PSI narrative reflects that he was on probation. Current status, I would just ask the court to consider that if he is to be determined on probation, if there was some sort of documentation reflecting that, other than the PSI, something that could be relied on, that would at least reach the preponderance standard, Your Honor. I guess in the case that would reflect whether or not it should be scored for guidelines challenges, which would generally be relied on by the people, is People v. Johnson. In that case, it does look at the original judicial sentencing guidelines pre-statutory authority or pre-statute guidelines. And Your Honor, with that, it does generally say that acknowledge that there was no, a person would not necessarily be on bond or probation if they are terminated or if they absconded and bench warrant has been issued. However, it does go on to reflect that that person cannot escape their status prior to that bench warrant termination of status. So with that, Your Honor, I just ask the court to consider the idea that he was not presently on probation at the time
Mr. Schneider, did you have something you wanted to add?
Yes, Your Honor. I just wanted to say that California just doesn't want me to come back to the state. Every time I get pulled over or anything, they are automatically called and they just don't want me to come back. They release me every time. So I'm still on, where we say absconding, whatever on their thing, but they just don't want me back. And you can call California yourselves and they will say that. I'm on my last PSIs since I've been in trouble. No one has put that on there. And they all know about California. It's 20 years old. They don't want me to come back there. You know, Your Honor, I'm not trying to run from it. I just, they don't want me back there and there's no other way to clear it up with them. But I'm technically not on probation. I wasn't on probation in Michigan. I was off parole successfully early. My last time I was in trouble 20 years ago was the last time I was ever in trouble. I have a drug problem, Your Honor, but I don't admit that. But I haven't been in serious trouble in over 20 years. I was even off parole early, and they knew about California. So that's all I have to say, Your Honor.
All right, thank you. I don't know about any of that. What I know, I don't know whether they want you back or don't want you back, and that really doesn't make any difference. What matters is the status. The PSI reflects that there is still an outstanding warrant for probation violation offense in California with the in-state pickup only. So there isn't anything that Michigan would do here, but it doesn't change the status, and the status is the basis for the scoring. And I think it's correct to say that he is on probation on the face sheet. So to the extent there's a challenge to the guidelines based on that status, the court will deny that challenge. The information in the report satisfies me by a preponderance, and just statements on the record, either from Mr. Schneider or Mr. Dick, are not enough to contradict the evidence in the PSI, absent some other documentation. So that's the court's ruling on that. Are there any other corrections to the PSI?
No, Your Honor, no additional deletions or corrections aside from the challenges.
So I did review your brief regarding the challenges. I'd like to address OB 15 first. I don't need you to repeat what's in your brief, Mr. Dick. Do you have anything additional that you want to state?
Not as it pertains to OB 15, Your Honor. However, just as a response to the prosecution's upward departure request.
Okay, I haven't even gotten there yet, so hold on one second. Mr. Rolla, is it fair to say that you're not challenging that the guidelines should be scored at OB 15 as you're arguing for 5 points?
As I indicated in writing to the court, but on that note, Judge, our office didn't even receive this objection on scoring until Tuesday, July 7th at 3:02 p.m. as I attached to that. And I think the court needs to stress again to counsel that as far as the challenges, they need to be making those in a timely fashion.
Yeah, my understanding was Mr. Dick didn't get it until then.
I don't know when he got it.
No, Your Honor.
I know when we got it, we had it in time, but I don't know when he got it. I can't say.
No, I received it Tuesday afternoon last week, but I was not able to prepare that. So I had some other matters.
All right, well, Mr. Rolla is correct. I mean, the court's policy is that challenges need to be in soon enough because, it ends up being an ambush of both the prosecutor and the court by defense when they wait till the last minute to submit those.
That was my intention.
And I get that, but that's what it ends up being. And so, yeah, Mr. Rolla is absolutely correct. Unless there's good cause for why it's not submitted in a timely manner, I'm not going to strike it this time, but we'll deem it to be waived if there's not good cause. And sometimes both prosecutor and defendant, they don't get the PSI until the day before sentencing, and then I get it. You can't possibly challenge something. But otherwise, it does need to be brought forward. We do have an agreement that OV 15 was improperly scored. And so the court is going to grant that challenge and rescore OV 15. Now, I am going to say, I know Mr. Dick, you argued for 0 and at the most 5. Prosecutors arguing for 5 points. 5 points is allowable when the circumstances indicate trafficking. And I think here, given the facts, there's more than enough evidence to, under a preponderance standard, to establish that there were circumstances to indicate trafficking here, which would allow for the scoring of 5 points. So the court is going to score OV 15 at 5. That reduces the total OV score to 6 points, which puts it in the OV 1 level, which reduces the guidelines to 10 to 23. I know both sides may have arguments regarding departure. To me, that's for allocution. We'll deal with that at allocution. So the guidelines as they stand now with the change to OV 15 are 10 to 23 instead of 38 to 76. And then Mr. Dick, OV 12 is scored at 1 point, and you're arguing that one as well. Do you have anything to add to your argument that was made in your brief on that?
No, Your Honor.
Mr. Shola.
Will be 12 basis for saying it's 1 point.
Yeah, it's scored at 1 point now for one contemporaneous felonious act.
That was my understanding.
Dick is arguing that there isn't any contemporaneous felonious acts.
And as the court's well aware, it does not require a conviction for contemporaneous act. So it would be our position that it's properly scored.
Right. So the court finds that there are a number of different acts, and this is again based on the facts contained within the PSI under a preponderance standard that this vehicle was being the vehicle that Mr. Schneider was found with the substances in it, was being used as part of a larger scheme by Mr. Schneider and others, including Ms. Moses, who I sentenced earlier today, for the transport, distribution, and sale of methamphetamine. Ms. Moses was charged with maintaining a drug house. Based on that, in this case, I think Mr. Schneider certainly could have been charged with that as well. He wasn't. It's a contemporaneous act. It occurred within 24 hours of the sentencing offense, and it does not form the basis for an additional conviction. So based on that, the court finds that 1 point is properly scored. Regardless, it's largely academic because even if it was scored at 0, the point OVs would still be 5, and you can't get any lower than level 1, so that wouldn't have changed the outcome of the scoring and the guidelines regardless. But either way, the court finds OV 12 is properly scored at 1 point, so the guidelines will remain 10 to 23 months, which is the lowest possible guideline with the PRV score possible. So with that, Mr. Dick, are there any other challenges to the scoring?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
None of them are addressed.
Do you have any challenges to the scoring?
None other than what's already been addressed on the record.
Thank you. Anything then for allocution on behalf of the people?
Judge, yeah, in this particular case, this is a possession in that case, and it's a 54-gram possession in that case. This would be the defendant's 7th felony, 2nd controlled substance that, as you can see, under number 14 or 16 is a adult record. And he also has another pending matter, number 16 or 16, although that isn't going to sentencing yet. And I apologize to the court for not getting my response to defense's objections and challenges until this morning. But since our office didn't receive that challenge until sometime late yesterday afternoon, and I couldn't actually address it until I got to look at it this morning. So in any case, I think what's perhaps important, fortunately for the prosecution, is this is the same issue that actually is raised on the matter for tomorrow that's before Judge Hunter. So I had already done the research on it. So it didn't take quite as difficult a time to correct it. But under the holdings as indicated in Bradley and also as set forth in my brief, it's under the Lamp case as well. Bradley's not binding upon this court, of course, because it's a non-published case. But I found because of the similarity of the facts scenario in this matter, I wanted to provide it to the court. And that's actually the one that I relied upon in indicating the score should be 5 points under OV 15 as opposed to 50 points. But under Lamp, as the court found, there's a significant destructive nature of methamphetamine, especially when we have the type of quantity of methamphetamine we have here. That's simply not addressed in the guidelines. And while I understand arguments are made often by defense counsel that, well, when the legislature set those statutes, that's a long time ago, when we had a real big difficulty with methamphetamine being made all over the place. Quite frankly, Judge, I think that argument falls flat factually, because I think, as the records would show, at least according to the drug records I get from both Michigan and across the country, methamphetamines coming to the United States are far greater than they've ever been, although there's been, fortunately, thanks to the border now being closed, some level of stoppage in that regard. So the danger hasn't gone down. It's actually increased because of the amount of precursors that are now in Michigan. Under that circumstance, and under the way we went, the court would not abuse its discretion in going beyond the guidelines. Because, of course, methamphetamine is not, although the legislature has addressed it and saying, look, we're considering this a Class B 20-year felony, for some reason the guidelines have chosen not to do so. Thank you.
Thank you, Mr. Deck.
Yes, Your Honor. So just in start, as the court is well aware, look at the PSI and see that Mr. Snyder's had a substance abuse issue from a young age. He's been dealing with it for a long time, and he finds himself now, unfortunately, in the prison system, where hopefully he is able to receive the help that he needs and fully learn how to address his substance abuse issues. This particular case is no different. This is another case where somebody who's addicted to methamphetamine is finding himself in a circumstance that he wouldn't otherwise find himself in had he just been, for instance, consuming alcohol. Well, the prosecution is correct that the legislature did find that there was a good enough reason to make this a severely penalized drug as compared to its counterparts. It also found that there are certain carve-outs, specifically, not that we're asking the court to do anything with probation today. However, the legislature specifically addressed a carve-out for methamphetamine, understanding that it is a highly addictive substance and that people would be perhaps do things that they wouldn't otherwise do, and allowed people to be sentenced under the Probation Swift Assure Act, which would permit them to be on a delayed sentence of 771, which would not necessarily be otherwise available to somebody who is transporting such as cocaine or something of that nature. This particular case, Mr. Schneider, Your Honor, he's being convicted of simple possession. He is not pled guilty to possession with intent to deliver. He did not admit to possessing more than 130 grams of methamphetamine, as Bradley states, and these facts are going to give Bradley right here. So in Bradley, the defendant pled guilty to possession with intent to deliver, admitted to more than 130 grams, admitted that he planned to sell the drugs, and the co-defendant there reported 5 to 8 prior trips to obtain methamphetamine for further distribution. That's where a departure was upheld. However, in this particular matter, this is one instance where Mr. Schneider found himself in a car where he was not the driver, he was not in possession or control of the vehicle. He did acknowledge to the officers that he thought he would get something for going for the ride, some methamphetamine, and he also admitted smoking. So, Your Honor, with that in mind, he reflects everything of an addict. He doesn't reflect somebody who is here going through motions to be, forgive me for the term, like a kingpin drug dealer, or somebody who is looking to do this for pure financial gains. That being said, Your Honor, the Lamp Also, it didn't hold that just methamphetamine, just by its mere destructive nature, justified upward departure in every case. It was that one particular case where there were significant additional factors. Here, Your Honor, I do not see that there are all of these significant additional factors. Mr. Schneider finds himself in prison on possession charges. He finds himself there a couple times because he's an addict. With that in mind, Your Honor, we would ask that the court administers a sentence within the guidelines.
Thank you. Mr. Schneider, was there anything you wanted to say today?
Yes, Your Honor. I just wanted to say that that time of my life was probably the hardest I've ever gone through. I lost everything. I was homeless, lost my car, lost my job, lost a lot of friends and family from my addiction, I wasn't out there selling drugs. I was broke on the street. I wasn't, some big flashy drug dealer. I just was in the car just so I could get high. And I was homeless too. So it was the middle of winter, so I had nowhere to go. And I'm in the ride just to stay warm and have, to go somewhere just so I had someone to shelter and stuff. Like I really didn't have nowhere to live. I had, and then I found myself when I went for this case, I went to prison, stranded in Petoskey, it's all on the same day, pretty much all this happened. And I'm in prison now, Your Honor, for literally residue. I'm not some big drug dealer. I had to use every day or I would get sick. And I find myself with nothing, and I'm in here for 3 years. I'm trying to regain my life. I go to NA classes, go to a digital learning class. I am trying to better myself, and I don't know, I don't ever want to go back to that. And this has been hard, Your Honor. I stayed out of trouble for almost 20 years, and then I started doing meth and just everything went downhill. And I'm sorry that I was in that situation. I should have never been in that. And I can't take it back. I can just learn from it, and I just want to move on with my life and do better. And I know you hear this probably a lot, it's cliche, but it's the truth. And with that, that's all I have to say, Your Honor.
All right, thank you. I did review the pre-sentence report, Mr. Schneider. I'm familiar with the circumstances that bring you before the court today. I'm quite familiar with these circumstances. As I indicated, I sentenced Ms. Moses earlier today for her involvement in this operation of bringing drugs up to northern Michigan from downstate. Mr. Kruger, who was in the car with you that day, took his case to trial. He was convicted. Interestingly, he made the same argument that you're making, which is, he's not the one, that he was just driving the car. He wasn't involved in the dealing of the drugs at all. And of course, your position here today is you were just riding in the car and you weren't involved in the dealing of drugs. And I don't really know who's right and who's wrong. You guys are the only ones who really know that. Everybody's pointing the finger at everybody else, which isn't unusual and not unexpected. But the fact is, you were in a vehicle that was used regularly to transport methamphetamine from downstate up north. You were in it this day with Mr. Kruger. That's exactly what was happening. And you're right, if you weren't really involved, you shouldn't have been there. And if you were, then you shouldn't have been there either, frankly. And you were involved in the transportation, directly or otherwise, of a fairly large amount of methamphetamine, 56 grams, to northern Michigan. And the court has an interest in punishing that kind of conduct because not only is it harmful to you as a user, but it puts methamphetamine into the community so that other people can use it and be harmed by it. And so you were involved in a process that provided for that. The court has an interest in deterring that and punishing that kind of conduct. Given the nature of your past record and the circumstances here, the court finds that a sentence within the guidelines is appropriate. The court does not find that there's such aggravating circumstances that it should go above the guidelines. However, the court finds that a sentence within the guidelines and a prison sentence is warranted given the nature of the offense. The court is going to sentence you to 23 months to 10 months, 10 years in the Michigan Department of Corrections. You have credit for 0 days served on this charge, a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. The sentence to be served concurrent with any other sentences you're currently serving. You do have the ability to seek an appeal of this sentence. The court will provide you with your appellate rights. Your time for filing an appeal will not begin until you receive those rights and acknowledge receipt. But those will be coming to you if you haven't received them already. Mr. Roll, is there anything further we need to address on the record here today?
On this matter.
Mr. Dick.
Thank you.
Mr. Schneider, that concludes this hearing. You are remanded to the custody of the state at this time, and the court is going to disconnect. All right, we have Mr. Gens present.
Yes, sir.
People versus Gens, file number 266998. Mr. Gens is present here in the courtroom today. Mr. Dick, how do we want to proceed with this file?
Your Honor, today we will be entering a
No, it sounds 2 and 3 with half second. And we read that to 2 and 3 without. Originally constructed to state. As later said. As I have said.
sorry, and 2 minutes.
We need to move things along. We're way past time on your docket. We're already 10 minutes past the hearing that was supposed to start at 3:30.
Your Honor, today, I just want to confirm, today's a plea cutoff date. Is that which court had stated last time?
Yes, it is.
Your Honor, we're going to enter plea to counts 2 and 3. Two of them, charges would be dismissed.
Is that correct, Mr. Rolla?
Yes, it's please to count 2 and 3 all of the counts will be dismissed and then we'll convert to a third notice.
Okay. Mr. Gentz, do you understand the plea agreement in this case? Okay. And under that plea agreement, you plead guilty to, it looks like, 2 counts of resisting or obstructing. Each of those counts carries with it a maximum possible penalty of up to 2 years and or a $2,000 fine. Is that your understanding of the agreement? Okay. And are you going to proceed with that agreement today? Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Mr. Gentz, are you currently on any kind of probation or parole? All right, and you understand those maximum possible penalties that I've just stated to you? With those in mind, what is your plea to each of those charges today?
I plead guilty to those.
All right, right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the court. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights? Do you understand that you're going to be giving up and waiving all of those rights by pleading guilty? Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you have to ask the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand that? Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court today? Is it your own free choice to enter this plea? Are you pleading guilty to these 2 charges because you are actually guilty? This happened back on February 16th, 2026. Is that the correct time?
Yes, sir.
And on that date, were you present here in Otsego County?
That was your honor.
And on that date, did you come into contact with Trooper Leonard of the Michigan State Police? Or a Michigan State Police officer?
Yes.
He was.
It was, yes.
And was that officer wearing his uniform?
Yes, he was.
Okay. And then did you also come into contact with the deputy from Otsego County?
2 that I know of from the video.
And did you know that they were all police officers who were there performing their duties?
Yes, sir.
Okay. And what happened that would cause you to be guilty of resisting or obstructing at least 2 of those officers?
It would be for resisting. I don't know exactly what I did. I woke up in jail and okay. I don't, I mean, other than watching the video, in the video, there was no resisting that took place that I'm aware of. The only place that it is said that that happened is in the police report that it just says that I kicked out the officer. And in one video, I believe the sheriff's deputy was talking to the state trooper and said that I had made contact with his shoulder.
Are you telling me that you don't have any recollection of any of this incident with police officers?
Only from watching the video.
I don't want to talk about the video. I want you to think about what's in your mind.
I don't remember any of it.
Zero.
I don't remember them showing up. I don't remember calling them. I don't remember any of the interaction. And I just woke up in jail and I was covered in blood.
Why don't you remember?
I was drinking.
How much did you have to drink?
I drank a pint of Pava. I believe that had been gone, I don't know how long, until I had already had another bottle. There was a pint of gin, and it shows me drinking that bottle of gin in the video, talking to the troopers. Other than that, there was nothing else.
Drank 1 pint of alcohol and you were blackout drunk.
Vodka. And then I drank a pint of whiskey.
Well, we can't take a guilty plea, so counsel, how do you want to proceed?
Your Honor is willing to set it for a plea hearing aside from today. Where copy of the affidavit of probable cause.
I don't know what you're saying. Do you want to proceed today with a different type of plea? What do you want to do?
Yes, Your Honor, if Mr. Getz would be permitted to enter into a contest plea.
Mr. Rolla, do you have any objection to a no contest plea?
I do not, Judge. I'm reading again the affidavit of probable cause in this particular case. And although it does not indicate specifically the defendant's blood alcohol, he consumed what he claims he's consuming. And from what I see, the officers are doing this effectively as a wellness check to have him also be checked out because he was also apparently expressing suicidal ideation. I see no reason that a no contest plea couldn't be taken for lack of memory purposes.
All right, so you don't have an objection to that.
Correct, Judge.
Mr. Gentz, a no contest plea occurs when circumstances like this, where an individual is about intoxication, can't remember what happened. They don't contest the facts of what took place. It's not a guilty plea, but it has the same effect as a guilty plea. In other words, I will find you guilty of the charges, but not based on your own recollection, but rather based on the information contained within a police report, or in this case, an affidavit of probable cause. You understand that? Okay. Do you have any objection to proceeding as a no contest plea? You understand that everything that we went through with regard to your rights, changing this to no contest plea doesn't change anything about that. You're still giving up all of those rights, and any appeal would still only be by me. Nothing really changes other than, rather than relying on your testimony, I'm going to rely on information in this probable cause affidavit. All right, so the court's reviewed that affidavit. It does indicate that Mr. Gentz was visibly intoxicated. So based on his testimony and the statements within that, I would find that a no contest plea is appropriate. It does also indicate in here that Mr. Gentz was actively resisting, that he was taken to the ground, that he was kicking at law enforcement. So I find that there's a factual basis. Mr. Rolla, would you agree?
I would, Judge.
Mr. Deck?
Yes, Your Honor.
So the court's going to mark and admit that affidavit as probable cause as Court Exhibit 1 and accept that as a factual basis. Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your
Mr. Dick?
No, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest plea?
Yes, Judge.
Mr. Dick?
Yes, Your Honor.
Mr. Gentz, the court finds that your plea is knowing, voluntary. The court finds that based on the information in Court Exhibit 1, there is a factual basis to support a finding that you are guilty of 2 counts of resisting or obstructing. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date, time of that hearing. Before you leave today, you're going to meet briefly with Mr. Brunical from the probation department to set up a time for pre-sentence report. When questions at all.
I would just like to be able to have this looked at better. Or I don't know how much you have looked at it, or but I feel like this was more of a cry for help than it was for me trying to act out and do anything to deliberately cause a situation.
Well, yeah, I mean, we can certainly talk about the circumstances at sentencing. And I can understand a cry for help. I read in there that we're not in a good state of mind. That doesn't give you the right to kick and spit blood at
Absolutely
police officers. So
I take full responsibility.
yeah, but certainly I take mitigating circumstances into account. That'll all be part of the sentencing. So you'll have a full chance to tell me about all of that. Thank you. Sure. Yes. Mr. Farner, is Mr. Farner present?
Yes, Your Honor.
People versus Farner, file number 266992 and 6993. Record should reflect Mr. Farner's present here in the courtroom today. Mr. Dick, how do we want to proceed with these files?
Your Honor, we are going to take advantage of a plea offer that's been extended by the prosecution. Where Mr. Farner will be pleading guilty to count 1 in file number 993 and 2 in file number 992.
Judge, I'm sorry, can he repeat that?
What is it?
Can he repeat that? I'm
Yeah, can
sorry.
you say that, Mr. Dick? We need you to speak up. I'm having a hard time hearing you too.
Mr. Farner will be pleading guilty to count 1 in file number 993 and pleading guilty to count 2 in file number 992 in exchange for the dismissal of all other counts in each file.
Mr. Rolla, is that a correct statement of the plea offer?
Yes, Judge.
Mr. Farner, have you had an adequate opportunity to speak with your attorney about this plea agreement?
I have.
And what we've discussed here today, those 3 charges, is that your understanding of that agreement?
Count 1 and count 2. Count 1 in file number 993 and count 2 in file number 992.
Yes.
Yes, we have, sir.
Okay. And is that how you wanted to proceed? You raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Farner, are you currently on any kind of probation or parole?
I'm not, sir.
You understand that in file 6993, you're pleading guilty to 1 count of delivery of methamphetamine that carries with it a maximum possible penalty of up to 20 years and or a $25,000 fine. You understand that?
I understand.
And in file 6992, you're pleading guilty to 1 count of possession of methamphetamine that carries with it a maximum penalty of 10 years and or a $15,000.
I understand.
Right. With all of those things in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. You have the right to have trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
I do, Your Honor.
You understand that by pleading guilty, you're going to be giving up and waiving all of those rights.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask for the Court of Appeals to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. Do you understand that?
I understand.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here today on the record?
No, Your Honor.
Is it your own free choice to enter this plea?
It is.
Are you pleading guilty because you are actually guilty?
I am.
It looks like these incidents occurred around May of back in 2025, so a little over a year ago. Is that correct?
That's correct.
And at that time, were you present in Otsego County?
It was.
And while you were present in Otsego County at that time, did you have possession of some methamphetamine?
I did.
And did you have some of that for, did you give or sell some of that to someone else?
I did.
Did you have any legal right to do that?
No, sir.
And did that occur on at least 2 occasions?
Sale of methamphetamine, Your Honor?
Yeah. I know we're taking the plea to possession, but I'm gonna take the plea agreement involved possession. I'm taking the factual basis that the two charges of delivery, because it's too hard to parse out the possession with intent. So did that occur on at least?
Yes, sir.
And just so you know, Mr. Farmer, I mean, you're not being convicted of 2 counts of that higher charge.
That's why I was being held.
Yeah, understood. Okay. All right, and you didn't have any legal right to possess it or deliver it, is that true?
No, sir.
The court finds that the plea is knowing, voluntary, and accurate. Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Judge.
Mr. Hicks.
Judge, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Dick.
Yes, Your Honor.
Mr. Farner, again, the court finds there's a sufficient factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to each. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to touch base with Mr. Brunical briefly from the probation department to set up a pre-sentence interview. Do you have any questions?
I do not, sir.
Thank you, that's all. Mr. Millsap, if you want to go ahead and have a seat next to your counsel over there. On record in People versus Millsap, this is file number 256912. The record should reflect Mr. Millsap's present here in the courtroom today. I can have counsel put your appearances on the record.
Director John, my phone.
Thank you, Your Honor. Attorney Marcus Beldor, on behalf of defendant Millsap, sitting to my right.
All right, we're on the record today. We've got trial dates coming up in August, and we have a number of motions that have been filed by the defendant. Mr. Beldor, I did have a chance to review your motions. I know that you submitted something today. Didn't get a chance to look at that.
That's okay. Thank you.
Mr. Rolla, I did get your responses. I had a chance to review all of those as well. And so, Mr. Baldori, unless they're your motions, unless you have a different preference, I was just going to take them in order as you have listed on the notice of hearing.
Sure, Your Honor. Well, let me preface. I'd like to start generally with the motion to dismiss and the motion to remand, just from a general framework standpoint.
Certainly.
I appreciate the court's time with this. There's a few motions, obviously, as the court has noted. I want to work through them today. I think this case needs some attention. And I believe there's serious foundational issues with this case. I don't use that lightly. I don't say that in other cases. Given the seriousness of the charges here, what's going on, I truly believe there's serious foundational issues with this case. And he's charged with 2 counts of CST first, 25-year minimum. Attorney Mataloni was previous counsel and was counsel during the when defendant Millsap waived the preliminary examination. Mataloni died in December 2025. I subsequently filed my appearance and got on at around February, January this year. I want to walk through a little bit of the timeline in this for the factual basis of this case. The alleged incident was when the minor child was approximately 2 to 3 years old, and the defense the prosecutor initially had their investigation in 2019 when the alleged victim August was 8 years old. At that time, she didn't remember anything. She said, "I don't know, I don't remember." That investigation, they also interviewed August, the mom, who is now deceased. That investigation was closed, and the prosecution found there was not sufficient evidence to charge. In the prosecutor's response, Mr. Roller's response to the motion to dismiss, in paragraph 6, it says, "The original statement allegedly obtained from the victim at the time of her October 3rd, 2019 CAC interview was as set forth in the complaint, did not amount to a first disclosure, as the minor victim was unable to recall, much less provide sufficient information to allow for the charges to be authorized." So time proceeds. February 2022, they declined the warrant arrest. They declined those charges. It's resuscitated in 2023, June 2023. And she's forensically interviewed in June 2023 at Roscommon's Children's Assessment Center. I've reviewed that. It's completely, I don't know, can't remember, I don't know. 100% of the interview, no disclosure. Then follow-up interview, June 20th. And this is all through the correspondence with the new foster home that she's in. June 20, 2023, follow-up interview. This is the one where there's supposedly this key foundational piece of evidence. It's a handwritten note. It's an interview with an officer, and the officer is asking her questions. Again, I don't know, can't remember. It wasn't good. I can't remember. I don't know. Is there anything else you want to show me? She goes like that. This document is not written by her. This is written by another foster child. And the words that they're using, the prosecutor's using, is that it's dictated by another foster child. My dad, Alan, spelled wrong, stuck his penis in my private. And then all the rest of the text is written, or is complete about totally different stuff. Verbally, I don't know if that even is verbally, it's I don't know, I can't remember, I don't know. You have to think about the time frame here. She was, this supposed instance that she couldn't remember, that the prosecutor said there was no disclosure because she couldn't remember and couldn't recall in 2019, is being resuscitated when this is supposedly a recollection when she was 2 years old in 2013. This provides the context for why these motions need serious attention. Because one thing that I'm shocked as I got into this case and I started looking at the discovery that was sent to me, which in my view isn't thorough, and I will get to that with the motion to compel, but it's not, is that I don't have a clue why Mr. Mataloni waived the preliminary examination in this case, or advised my client to waive that exam. To me, that is absolutely malpractice, and I respected Mataloni as an attorney, but I cannot fathom how an attorney could have waived the preliminary exam in this case, because I do not see it. I don't see how there's certainly a serious challenge to the probable cause for this case. If there's ever a case where you run that exam, it's this case. And we're at the point where we're heading into a potential jury trial, which I'm going to ask for an adjournment, but it's scheduled in August, where he's facing 25 to life on this case. And he's taught, he said, Mataloni said, we'll just do fine at trial, let's waive it. That's like one of the main barriers that would have been potentially super effective in a case like this, where you got facts like this, where you got a case that was dismissed initially on the investigation, where there's an interview. Again, that initial interview, It's gone. It's deleted. That's in the police report. It's deleted. It's gone. And they're saying, well, there was no disclosure. I don't know what was in that. It could have been totally exculpatory. That no longer exists. And even the stuff that does exist, the videos that do exist are this, I don't know. I don't remember. That's it. And for a letter that's double hearsay, so that, I know those two motions, motion to remand for preliminary exam and motion to dismiss are extreme. I mean, you don't expect those to be granted in cases. I mean, there's not a lot of cases where either of those happen, but I found a case, I submitted that supplement this morning. The circuit court does have discretion to remand if the circuit court finds there was not sufficient basis or probable cause. And given the facts and the severity of this case and the attention that this case is warranted, when you've got a 8-year-old who said, I don't remember, and then 3-4 years later, still I don't remember, and it's brought for when I was 2 years old, that warrants a lot of attention. There's just something foundationally at issue here, and I'm partially trying to get a sense of where the court might be at with this, because to me, there's serious red flags in this case. So that's as to my first, those two motions. And I don't know what kind of relief that the court might be interested in providing. I know.
Well, here's the thing. I mean, it doesn't go on my feelings or red flags. I've got to follow the law, right? And so there are certain standards in the law for when the court can remand cases to district court. Mr. Rolla cited the cases that I found as well, the Taylor case, which didn't fit any of these circumstances. I generally would agree that the court has discretion not to just remand for an additional probable cause determination. Usually that happens once there has been a prelim and or remand for additional factual findings and so forth. But where it was waived, I mean, that's a real problem for you. And I get that you may not have done it, and I get that I may not have done it, but that's not an exception. So why don't you tell me, because I didn't have the chance to read it, what the authority is that you found? Or is it just generally the court has a discretion?
I do think generally, no, I think the case that I have here, they may have held one that it was remanded because they said there wasn't sufficient of.
Yeah, because everyone I found, it was run and then it was.
And that may be, and if the court is interested in potentially holding this in abeyance, so I can find something where that may have happened. But when you're dealing with the severity of the charges, you put everything together, it just warrants attention. And if the court determines there's no authority for that, I can't produce authority that doesn't exist. So there's that.
Well, I'm just asking whether you found something that I didn't find or that Mr. Rowland did.
If a motion, yeah, I mean, people be tailored. Once a criminal case has been bound over in jurisdictions vested in the circuit court, there are limited circumstances where a circuit court may properly remand the case for a new or continued preliminary examination. If a motion to quash is filed and the circuit court determines that the evidence is insufficient to support bind order, the circuit court is permitted to remand the case for their examination. Again, it doesn't talk about waiver. I get that. I'd have to look more to see if there is. I couldn't find one that had a waiver. So that's what it is.
That's just what I'm asking.
Yeah.
You found something that I didn't. All right. I want to hear from Mr. Rolla on this issue because I think this is a threshold issue that will impact how we move forward with the other motions. Mr. Rolla.
Thank you, Your Honor. As indicated in my brief, Taylor is controlling the cases cited, some not cited, some cited after I actually provided response. My office provided responses to this motion. Make it very clear. This is a waiver. The circumstances that defense is trying to claim this court has authority to remand just simply do not exist as a matter of law. It's a circumstance where there are factors and certain situations where a waiver can take place, as the court indicated, and as I cited before, those very, very narrow circumstances. This is none of those narrow circumstances. There is no legal authority after a waiver. That's what a waiver means. You've waived your right to challenge probable cause.
So, yeah, go ahead. In those cases, it didn't discuss waiver. Okay, so I can understand just the general principle of waiver itself may be dispositive to the court. It's a waiver. I get that. They stand up there and the court reads them their rights. They say, yes, I've considered, like the back and forth that they testified to at that time. That makes it hard to overcome. I can understand that.
Well, and so my next question then, to you, Mr. Daldori, and I know that you're not in the mind of Mr. Mataloni, and I'm assuming Mr. Millsap took the advice of his attorney, and so probably wasn't a lot of discussion between the two of them on it. But can you tell me, Mr. Daldori, maybe you can't, is any of this information that you have different or new information that Mr. Mataloni?
My belief is that he didn't have any of the interviews and he hadn't looked at any of them.
Well, hold on.
Well,
whether he looked at it is something that
I agree.
but we know what information was disclosed to him and what information wasn't. And so my question to you is, has there been information disclosed to you by the prosecutor since you took over that was not disclosed to Mr. Mataloni?
I would have to have that conversation with the prosecutor. I believe absolutely the answer is yes to that question. Now, I can't identify it as I stand here today. It's a great question. I'd like to get the answer to that question. That's a conversation I can have with Mr. Rolla. I wish I had that as I stand here today as you ask me that question. I believe the answer is yes to that question, because I had to ask Mr. Rolla for various different videos, CSC videos. We could ask Mr. Rolla right now. I don't believe that a number of those videos have been disclosed or sent to Mr. Mataloni. It could be 0 of them.
Mr. Rolla, and I'm not in any way implying that your office didn't properly disclose the things, but as a case proceeds, things are discovered by both sides. But
the discovery that was sent to Mr. Beldore's office is the same discovery that was sent to Mr. Mataloni's office. The only distinction that was not sent to Mr. Mataloni's office is Mr. Mataloni's office did not ask us to produce information or documentation regarding the polygraph that he knew we could not produce legally as a matter of law. And that's one of the other motions.
Yeah,
So when I say information was provided to Mr. Beldore's office that was different, yes, that's because Mr. Mataloni's office didn't ask for what they were not legally entitled to in the first place.
I'm going to take a break for a minute because I want to check something in the court rules before I rule on this motion. Is there anything last you want to say on this issue?
Yes.
Judge, if it makes it easier for the court, and that's why I attached a numerous amount of exhibits to my motion. In defense counsel's pleadings, they falsely allege that a lot of documents were not provided to them. As I provided to the court, not only were they provided, but I provided the verification that they were provided.
Well, again, we're getting into the motion to compel.
I understand that, Judge.
I don't want to talk about that. All right, give me a minute here, and I'll be right back.
All rise.
Okay, we're back in the record. Thank you for everyone's patience. I wanted to hear the arguments of counsel on that particular issue, and I appreciate. You want to say something?
I did. I didn't know if the court's going to issue a ruling.
I am.
Okay, so I wanted to add before the court issues a ruling, just to maybe just make a small record here. Looking through the responsive document from the prosecutor, this is a big issue here. I don't know that there's anything in this document that said the videos had been sent to Matt Olney's office. I'm not seeing that represented in here.
Let me just, that's not relevant.
Okay, it's not relevant. Fine.
So, in considering whether or not this is something that, despite the waiver, should be remanded for a preliminary exam. Number one, counsel, I appreciate your advocacy, your zealousness, but you want to be careful when you're making statements like this case warrants serious attention. We're in circuit court. We deal with felonies. Every case that comes before the court warrants serious attention. So just watch yourself when you make statements like that, because some judges could take that to imply that the other cases don't warrant serious attention. Every case warrants serious attention. And I just say that it's a comment. The rules are what they are. The court rule doesn't provide for a remand under these circumstances. We've discussed the case law, which doesn't explicitly provide for a remand. But it's also my view that a circuit judge, generally in felony cases, district court judges in misdemeanor cases most likely, have general discretionary authority to take actions to prevent a miscarriage of justice or to take action in the interest of justice. For example, a court can grant a new trial for any reason that might warrant appellate reversal or in the interest of justice or to prevent a miscarriage of justice. The court can set aside a jury verdict because it's against the great weight of the evidence, which is an interest of justice type of exception. The court can allow defendants to withdraw their pleas for the enumerated reasons or if it's in the interest of justice. And if the court has the power to undertake those actions within its discretion, I don't see why the same principles shouldn't apply in this circumstance where there's a waiver by a prior counsel and where there are circumstances such as we have here. And while this case warrants serious attention, just as every case that comes before the court, this is not the typical case from a factual standpoint. We do have a late disclosure. We do have a significant passage of time along the timeline of events here that resulted in the charges. We do have a previous investigation where the same allegations were looked at by a prior prosecutor. That prosecutor declined those charges. We do have, I think, some significant questions regarding the weight and probative value of the evidence, at least that I've seen as part of this motion. None of those things mean, number one, that this prosecutor isn't fully justified in bringing charges in this case. None of those things mean that a reasonable jury nonetheless could not conclude that Mr. Millsap is guilty of one or more of the counts in this case. None of those things mean that the case shouldn't have or wouldn't be bound over. But all of those things are factors I think that the court has to look at here when making this determination. In addition to that, while I'm not going to second guess Mr. Mataloni's strategic decisions, Mr. Mataloni practiced in this court, was a good lawyer. I clerked for Mr. Mataloni almost 30 years ago when I was in law school. I'm not going to second guess his decisions, but I think even if the people were to get a conviction, given the factors I just listed, I think certainly the first thing on appeal is going to be, or the first request is going to be an ineffective assistance of counsel claim for that waiver. And it creates, I think, some appealable issues. I think it could result in the alleged victim in this case having to testify more times than may be necessary if this case has to come back because an ineffective assistance claim for not running the preliminary exam or the court declining to remand it. So I think there are lots of issues there, even if the prosecution is able to secure a conviction later. And potential increased harm and stress to the victim by having this being prolonged even more than it already has been. Finally, I don't find that a remand would be prejudicial to the people's case. They're preparing for a full jury trial at this point in August. They're presumably preparing their witnesses, getting their evidence ready, and having to do that at a preliminary exam where the standard is so much lower of probable cause. The court finds that would not result in prejudice to the people. So weighing all the factors here, and again, implying discretionary power of the court to remand here based on a theory of the interest of justice. And this is for both sides, really, I think. Again, I think proceeding under these circumstances without having an actual probable cause finding is dangerous to both sides. So I'm going to grant the motion, Mr. Baldori. I don't think the case should be dismissed, but I am going to remand it to the district court for purposes of preliminary examination. What that also means is that in granting that motion, I'm divesting myself of jurisdiction over the case, at least temporarily, unless it's not bound over, which means that any of the other motions that were set for hearing today, some of them I don't think are going to be relevant necessarily to the preliminary exam, but would need to be heard by the district court judge. So, Mr. Baldori, what I'm going to do is ask you to prepare an order ordering that the case is remanded for a preliminary exam for the reasons stated on the record. Submit that either with a stipulation as to form from the prosecutor or under the subject.
Thank you, and we might be able to take care of this right now. I have what I think is a satisfactory order. If I can show Mr. Rolla and present.
Yeah, I have Mr. Rolla.
Okay, thank you. I'm presenting that to Mr. Rolla.
Title regarding motion to quash information agreement. It's not, the motion to quash was not granted.
Right, so
There's check boxes. One of the check boxes, this matter is remanded to district court for preliminary examination.
And it's not properly titled.
why don't we just have you prepare a clean order, Mr. Baldori? I think that's not an unreasonable request. And then once the case is remanded, then Judge Hessling, our district judge, will proceed.
I'm sorry, which judge name?
Hessling.
Hessling.
Mr. Rolla, anything further for the record?
Yes, there's two things, one of which the court addressed already, and that's the repetitiveness of having to have victims testify over and over again. As the court's well aware, the statute of limitations used to be for these type of crimes originally 10 years for felonies. It was then changed to 15 years and then increased to 20 to the victim during 21 years. So the delay, I don't think, is an appropriate use. I understand the person will abide by it, But for the record, I also want to correct, there were numerous statements on the record about there being only one written statement. As the court saw in the pleadings and the responses that the people filed, there's not one written statement, there's three. There's one written statement originally that the victim dictated to her older sister, that her older sister wrote. There's a second written statement from the victim when she had her psychological report and evaluation attached to that report. And then there's a third, more extensive written information that was done, and then with the victim's name actually printed in on the top to confirm it, that was given to during the CAC interviews, and that was reported. All of those circumstances, information has been provided with copies again of that information to the defense. So I would ask that they please cease and try and make inferences to the court that there's only one, because that is in fact an inaccurate statement.
Well, it is what it is. It's all going to come out one way or the other. So that's a ruling of the court. I'll sign that order once it's presented. Once that order is signed, then the clerk's office here will send the file back to the district court.
Okay, and Your Honor, just for my education, these motions that are currently filed here, do those stay active somehow in the court or just refile?
No, because again, I will no longer have jurisdiction over this case once I sign that command.
So there's, all right, I understand those motions will no longer be active in any way with circuit or district court at all.
Right, so you would need to refile whatever you decide you need to refile.
Thank you, Your Honor. Nothing further.
Thank you. That's all for this case today. That's also the end of the court's